The major challenge perhaps is the absence of claims. And the absence of claims arises for a variety of reasons, probably the most important of which is a combination of lawyers not having malpractice insurance, and secondly, that a significant number of claims, maybe the vast majority of claims, while involving significant money from the viewpoint of the potential claimant, don't involve enough money to make it worth the while of a lawyer working on a percentage fee basis to bring the case, and the client doesn't have the money to bring it on an hourly fee basis, and in fact, it might not be financially logical to bring it on an hourly fee basis, given the amount that's involved. So, the two big problems are probably insurance and how to deal with modest claims. Variety of kinds of ways that might be done. One, again, is increasing the presence of insurance. Either two different solutions. One is mandatory coverage, which exists now only in the state of Oregon. The other is mandatory disclosure of whether or not lawyers have insurance. It's been shown to potentially increase the likelihood that lawyers will have coverage. So that's one. A second would be to change some of the legal rules surrounding malpractice, such as thinking through some of the issues in statutes of limitations, thinking through some of the issues in damages, and thinking through some of the issues in how you deal with the causation problem. A final kind of solution would be to have alternative fora to handle them in, such as an ombudsman type system that exists in some of the other countries around the world, where essentially small claims can be brought without the assistance of a lawyer representing the claimant. Key takeaway number one is there needs to be a higher incidence of insurance for lawyers. Key takeaway two is that the problems that we're looking at really reflect lawyers largely servicing the individuals in small firms. One of the themes in the book is the notion of the two worlds or two hemispheres of legal practice that translates or carries over into two worlds or hemispheres of legal malpractice. Large firm lawyers certainly run into problems, and when they do, they're big problems. But it's very different kinds of problems, it's very different incidents of problems than what you see in small firms, solo practice. Perhaps the strongest selling point in this regard is that it is the only book-length treatment that looks at what legal malpractice really looks like, how legal malpractice cases tend to be handled, what the issues and problems are. It's not written from sort of a technical legal perspective. And even there's really little, there are case books, there are nutshells, and there are treatises that are geared very directly to people practicing in the area. But this is geared much more broadly.